yes, he was excluded in Gallagher because he did not consider hydrazine as a possible mechanism. We have since then have talked with him, and he's looked at the literature of there are the case reports that hydrazine can cause liver damage. He does not believe, he thinks more likely than not there are other reasons why. So it's a little different situation, but I'm really going, at least trying to address the first one is, does your order on issue preclusion, does that preclude medical specific causation? Because then if that's true, then I can sit here all day and argue about tenor and why I think Mr. Kemp is wrong and why he's allowed to be under the Nevada law to, after he's considered and taken account that hydrazine can cause liver damage, why there's other factors and why he thinks there's more likely not something else. But I think the key reason I brought this up was really to get the kind of the metes and bounds of your earlier ruling.
No, I understand what both sides are saying. For better or worse, I'm going to have to take a second look at that because I don't, there's just so much. I don't recall off the top of my head, you know, what, because I see Mr. Fears what you're saying, I see what you're saying, Mr. Kemp. I need to take another look at that. If it needs to be more specific, which it sounds like it probably does need to be. And so remind me what, because we still have all the briefs and papers, so that's good, but
So I think
which brief
it
is
would
it?
be a brief on issue preclusion.
No, this would be the.
Some partial summary.
First, he has to have an issue, Your Honor. He's arguing, oh, we can't have issue preclusion because I have a medical expert to say that there's another alternative.
No, so all I want right now is remind me which briefs I need to take another look at. That
Plaintiff's motion for summary judgment on issue preclusion. There were two responses. Hannah, which Milwaukee joined in Milwaukee, and then there was a reply in support.
Anybody know the document number by chance? Or the date it was filed?
You have that document?
Plaintiff's motion is 604.
604.
Hannah's opposition is 761. Milwaukee's opposition is 803, and the reply in support is 967.
Okay. Oh, that's wonderful. Thank you. And it's all in one of the many binders that we have now somewhere.
Your Honor, this is not. Yes, we disagree with your ruling. You probably know that. It's not going to stop me from sending a Christmas card to you, but we do disagree with all aspects of that ruling. I just want to know clarity on this one aspect.
I understand what you're asking. I can't answer.
That's fine. And so I just wanted to raise it now, so we didn't. If this is the time to raise it, we can get it resolved. You can get us, the clarification on this, which may totally be why, I'll be fine with having these motions be withdrawn. It just was unclear, and so if we get your ruling, we can defer these until later, and so we don't have any surprises at the trial.
All right. So what motion are we doing first right now?
That makes we have to argue the tenor motions now, whereas I didn't think we had to before. So I think we probably have to start with 23, Your Honor.
I think we can defer it.
No, we can't defer this, Your Honor, because the predicate for them wanting to rehear this ruling is that they have an expert.
They want to put tenor on, and so hold on, let me make sure I understand. So if my ruling does apply to specific medical causation, then defendants disagree with that as well, but would acknowledge, I think, the tenor is out based solely on that reason. Is that
He would be out on any causation opinion.
okay? Let's do the ones that I prepared for today. Tenor may, let's do the other ones right now. Other than tenor, what do we have?
Yeah, we have a good faith settlement motion from that hangs.
Okay.
You want to start? with that
Anybody
one?
oppose that one?
There's not been enough.
All right, so Hannah's assiduous scientific instruments, et cetera, motion for determination good faith settlement on OSTs. Granted for all the reasons in the motion and the fact that it's unopposed. Prepare a detailed order. Thank you. Do we have Dr. Sands? Is that? We've got several on Dr. Sands, right? Or
Yeah, sure.
so I've got Milwaukee's and Hannah's joint motion and limine to exclude Dr. Sands, and what are the related ones?
The real water motion for summary judgment on the plaintiff's parents' claims and real water motion in limine number 18.
Thanks. And the supplemental, I also had supplemental briefs on the summary judgment, right?
Correct, Your Honor.
Okay. So so I do have a lot of concerns, I guess I would say generally regarding Dr. Sands. There was talk about before a calculation of was the amount proffered $133,000 or whatever, somewhere in that neighborhood, and I been reviewing his reports. Did not see that. I don't believe in those. His reports conclusions seem to be exactly identical. Doesn't appear to really have evaluated any of the parents or guardians. The conclusions the exact same for every plaintiff, despite what appear to be noticeable differences in his quote unquote evaluations of the non-parent, non-guardian plaintiffs. His reports were disclosed on that February date, I believe. So there's more of a notice than perhaps would have been. But let's hear first, because these are all motions from the defense side of the room. So let's hear first from whomever wants to argue first, whether it's summary judgment or excluding him or whichever one.
Your Honor, this is Matthew Kaufmann on behalf of Real Water. we could do the motion for summary judgment first. Based on what your honor's saying, I'm pretty happy to submit this on the briefs. I just would like to make a distinction here, if I could.
Sure.
Plaintiff, and I understand generally what Mr. Pepperman says when this motion for summary judgment is about Dr. Sands, but really this motion for summary judgment is about notice and a failure to provide notice. It's not really about Dr. I mean, it is, but it isn't. It's more about the fact that we don't feel like they've complied with the legal requirement to provide us with the notice. And the fact that they didn't even raise the pleadings until their supplemental briefing, I feel is very telling. And for that reason, I would ask you to reconsider your original inclination and grant our motion.
Anybody else on the defendant's side? Okay. Guess that's it. And this is for anything related to Dr. Sands, to be clear, so.
So, Your Honor, on that point, I understand that
Hold
sorry,
Did-
Don Davis.
I want to be, okay, so everybody listen to me, please. So if anybody has anything to say about Dr. Sands on the defense side, now's your time. If you're all done with Dr. Sands, that's fine, but if anybody has anything to say about Dr. Sands on the defense side, now's your time.
Your Honor, I apologize. She was admitted and then she was put back in the waiver for some reason, so it looks like she's admitted now.
I could go first as far as motion
She's-
eliminate 18.
Yeah, I want to be, does everybody understand what I'm
I
saying?
understand now. I thought we were just asking specifically for the motion for summary judgment.
Oh,
but now
so-
that you're saying anything
So
stands
so,
perfectly clear.
are you understand what I'm saying?
I do now, Your Honor.
Okay.
Initially, I thought we were breaking it down between the notice issue and then their other issues
So they're all Dr. Sands, right?
they're all pertaining to the same witness, but notice and then reliability are two different things, and you've asked to hear them
Yeah.
all now, and so.
Okay, yeah, so, motion and eliminate, motion for summary judgment, anything and everything based on Dr. Sands, whether it's notice or whatever else. Please go ahead.
I'm going to speak in regards to Real Water's motion eliminate 18 to preclude Dr. Sands' testimony regarding the parents' pain and suffering claim. In addition to the fact that the arguments made in the motion for summary judgment that there are non-existent causes of action, Dr. Sands' reports did not evaluate the parents' cognitive emotional functions, did not evaluate post-traumatic stress disorders, did not evaluate the parents' neurological functions, and did not provide any computation for the parents' damages. His reports only addressed the minor plaintiffs. And with that, there's no timely opinions regarding the parents' damages and pain and suffering. And I will leave that and let others speak.
Okay, thank you.
We have
I'll talk,
Don Davis is on the line. Don.
I was gonna say, you all talked about somebody on Zoom.
Hi, Your Honor. It's Dawn Davis. I'm so sorry. I'm having a little bit of an issue with my camera.
Okay, that's fine. I can hear.
Okay, I apologize for that. So for Milwaukee, we have filed a motion to strike Dr. Sands in his entirety. And part of that motion, begins with the notice. We talked about this a little the other day, but psychological and cognitive injury claims, they were not made by any of the plaintiffs in the Gallagher matter. So we were surprised when they were being made in this matter. And as part of our motion, I believe it's Exhibit A, we provided you with all of these plaintiff fact sheets, and Section 4 of each one of those plaintiff's fact sheets asks them, a number of questions about the injury claims that they're making. And not a single one of these plaintiffs indicated that they were making any sort of psychological or cognitive claim. So with that understanding, I mean, we were surprised to say the least when Dr. Sands' reports were produced on the date that expert witness reports were due. You know, I'll give you an example, and I'm giving you this example because the Williams plaintiffs, Lyric and London, are, I believe, the youngest of the lot, and Dr. Sands is making future treatment recommendations for them all the way out until they're 21 years old. Consistent with her, well, with the plaintiff fact sheets that she prepared, the Williams mother, Sante Williams, testified during her deposition specifically that she's not claiming any psychological injuries on behalf of either one of them. So, to say the least, we were surprised when we saw Dr. Sands' reports. Using London and Lyric Williams as an example, their claims alone exceed $900,000. It seems like this was a last-minute endeavor. Dr. Sands did what appeared to be pretty hurried Zoom meetings with some of these plaintiffs' parents, you know, within the 10 days before the expert disclosure deadline. Dr. Sands acknowledged during his deposition that these Zoom interviews with some of the parents didn't amount to a neuropsychological assessment. Instead, he started calling them neuropsychological screenings. As part of his review, he looked at a select set of medical records, and then he administered a select part of the BASC-3 assessment with the parents. Your Honor, I'll tell you this. It would be one thing that after Dr. Sands did this neuropsychological screening, he gave the opinion that the kids needed to have a neuropsychological assessment. But without Dr. Sands even doing that, he makes this monumental leap to opine that every one of these kids needs to have neuropsychological assessments and psychological treatments until they each turn 21 years old. And I asked him over and over what the basis was for that opinion during his deposition. And he finally said that, well, you know, my opinion is really just based on the fact that I've taken that the kids were exposed to a neurotoxin as a result of drinking real water. He doesn't know the exposure. In fact, none of plaintiffs' experts give any opinions about the extent of alleged exposure to hydrazine. He said, in fact, during his deposition, that he really doesn't need to do a neuropsychological assessment. He stands behind all of these future treatment recommendations because he's taken at the fact that all of these kids at some point in time were exposed to a neurotoxin. And, Your Honor, the basis of our motion is Dr. Sands' opinions just, they don't have adequate basis. He did not do enough here to be able to make opinions extending out decades. And again, if he had just stopped at these kids need to have neuropsychological assessments, that's one thing. We attached as Exhibit E to our motion an affidavit that, or excuse me, a declaration that Dr. Sands prepared in a separate case. And, you know, his opinions here that his testimony here that his opinions are valid despite the things he didn't do are directly at odds with what he's said in other cases. He said that he can't be sure about his findings and opinions without having far more information that he has now. So I don't need to go through the cases that we cited or anything like that. I know the court looked at our briefing, but there's just not enough here. And Dr. Sands goes too far. So I think it is the court's gatekeeping duty to, if you're not going to full out exclude him. His opinions have got to be cordoned off to the opinion that these kids should go and have a neuropsychological assessment. If you've got any questions, Your Honor, I'm happy to answer them. But there's just not enough here for him to be able to give opinions that are so speculative that go decades into the future to the tune of hundreds of thousands of dollars.
Thank you. Anybody else on the defense side? Okay.
If it's okay with the court, I'd like to start by addressing the argument from Ms. Davis and other defendants that Dr. Sands' testimony is inadmissible as a whole. And then I'll address the notice issue, which I think is a subset of his of this overall issue. So the issue with defendant's position, as you've just heard from Ms. Davis, is that it's not supported by fact or by law. And I'm going to start with the law. You didn't hear one thing about the law from Ms. Davis in her argument. You didn't see in her motion any legal support for this notion that if a neuropsychologist doesn't do a personal examination, their opinions are unreliable and therefore inadmissible. We cited a number of cases in our opposition. They came back in reply and cited in opposite cases about medical causation and the level of exposure, which has nothing to do with Dr. Sands' opinions here. So first and foremost, I think it's important that the court understands that there is absolutely no legal standard or rule whatsoever that provides that a medical expert, or in this case, a neuropsychologist, has to perform a personal examination for his or her opinions to be admissible. We cited a number of cases for this in our opposition. There's two that I'd like to highlight today that I think are especially on point. First, Your Honor, in our brief.
Hold on one second. Let me turn to yours. Okay.
In our brief, Your Honor, we cited the Find versus United States case. It's a District of Hawaii case from this year dealing with the same exact issue, whereby the defendants in the case moved to strike an expert named Dr. Clark, moved to strike his opinions because they were unreliable, because he spoke to the parents rather than the children themselves. Same argument they're making here. The District of Hawaii reviewed that argument and they went and looked at first the Federal Judicial Center's reference manual on scientific evidence, pretty authoritative treatise. That treatise provides conclusions about persons.
Thanks. Simon, your opposition. Where am I looking?
Your Honor, let me pull the page number for you. Find is cited at page 6 of our brief under section 1.
I think I misheard the case name.
I may be mispronouncing.
No, that's understandable. Bear with me.
We cited the case in the brief for the general principle that the court found that a psychologist not interviewing the minor plaintiffs but interviewing the parents, it doesn't render the opinions inadmissible. What I want to point out is that if you go to page 6 of that actual opinion, the court got to that decision by looking at the Federal Judicial Center's reference manual on scientific evidence, and it provides that conclusions about persons who have not been directly examined may be drawn based on available records, like medical records, which is what Dr. Sands did here. And that's not remarkable because we see medical experts give opinions about record reviews almost every day. The other case we cited that I think is important for the court to be aware of, Your Honor, is U.S. versus Vallejo. It's a 9th Circuit case. And that 9th Circuit was reviewing a District of California case. And in there, the district court cited one of Vallejo's experts. It was a school psychologist. And there the court excluded the psychologist's opinion because the psychologist didn't personally examine the child. And when the 9th Circuit reviewed it, they found that that type of decision is reversible error. And why? is because that goes to weight, not admissibility. And in making that decision, the Ninth Circuit looked to the Daubert case from the United States Supreme Court, which provides that an expert is permitted wide latitude to offer opinions, including those that are not based on firsthand knowledge or observation. So right out of the gate, it's important that the court understands there is no legal requirement that an expert has to conduct a personal examination. That's true of medical doctors. It's equally true of psychologists, and the defense has not given you any authority whatsoever to support its argument on that basis. So let me move now to the facts. There's been a lot of argument about the term assessment and whether Dr. Sands did an assessment or not. The defense argues that he didn't conduct an assessment, and quite frankly, that's just wrong. He did conduct an assessment. He did a lot of things. He reviewed the medical chart for each one of the child plaintiffs. He had the parents fill out a BASC test, which he then reviewed and scored. He conducted an hour-long interview of the parents. And in the argument you just heard, the defense is saying he interviewed some parents and not all. He interviewed the parents, or at least one parent, of each child in the case. And he conducted an exhaustive review of the literature as to what happens when people consume a toxic substance like hydrazine specifically, and more importantly, what happens to children who are victims of suffering acute liver failure. That constitutes an assessment. What Dr. Sands testified to in his deposition is that assessments are not some one-size-fits-all thing where every single patient of a neuropsychologist gets the same assessment. You tailor the assessment to the patient at issue and what their needs are. Defendant's own expert, Dr. Etkoff, he agreed with that concept too. He doesn't give the same assessment to every one of his patients. Here, Dr. Sands' review of the medical charts, the parents' test scores, the interview with the parents, and the literature that he reviewed led him to find that all of these children are at severe risk of suffering neurocognitive impairments as a result of their consumption of hydrazine, and more importantly, them having suffered acute liver failure. And what's important to note about Dr. Sands' opinions in that regard is that he's not testifying that they're suffering a neurocognitive injury at this moment. The parents report that all things being equal, the children are doing relatively well. No child is seeking neurocognitive treatment at this moment. What Dr. Sands is cautioning us, and what the jury needs to hear, is that there is a high likelihood that as these children grow older, those neurocognitive issues that are related to their acute liver failure are likely to manifest themselves. And we don't have the benefit of delaying this trial for 18 years until we know one way or the other. So what Dr. Sands is doing is he's prognosticating that there's a likelihood that these children will manifest neurocognitive issues in the future. And if and when that happens, they're going to need treatment. And what do we do to gauge against the possibility that they're going to need that treatment? They need to have assessments done every year or two until the age of adulthood, be it 18 or 21. Now, that is a reliable opinion that the jury should hear. The defense can cross-examine him with all of the things you just heard Ms. Davis argue. And that's why the courts have found that opinions like Dr. Sands go to weight, not admissibility. I'm going to address a couple items that came up today as well. First, the notion that the fact sheets are identical, or excuse me, that Dr. Sands' reports are identical. They're not identical, but they reach the same conclusion, which might be remarkable in a different case, but not this one, because all 5 of the children have a nearly identical pattern of injury and treatment. They drank the same water around the same time, suffered acute liver failure in the same outbreak in 2020, all went to the same hospital, all treated with the same doctor at the same hospital, received similar recommendations from that doctor, and all narrowly avoided having to undergo a liver replacement. So it's not remarkable that Dr. Sands' opinions are the same. When you look at the medical chart, Almost all of the medical doctors' opinions are pretty much the same. So I think that argument is a little misleading. All of the plaintiffs here that are the same. That's why we're trying this case together. Next, the fact sheets about psychological injury. If you take a look at the fact sheet where this is asked is under question or section 5.
I think you put this in a footnote, maybe somewhere.
It is in our opposition. It's at a footnote at the very end, I believe.
Hold on one second, bear with me a second.
Yeah, it's at the very last page of our opposition brief, page 11. Last 3 lines of the footnote.
Oh. Yeah, this was, as an aside, when I read this footnote, I thought, oh, this might have been better in the body.
And I agree that the defense has placed maybe an increased significance on this point now.
Hold on, let me refresh my memory here. Oh, yeah. Okay, yeah, I remember reading that.
Yeah, so the key point there, at least that I'm touching on at this moment, is what the fact sheet asks is, has the plaintiff been treated for any psychological, psychiatric, or emotional problem? And the answer there is no. That's an accurate statement then. It's an accurate statement now. But again, that doesn't have any adverse impact on Dr. Sands's opinions here. He understands that to be the case and understood it to be the case when he wrote his reports in this matter. The fact is the children at this point haven't had a psychological injury. The point is they're at a severe risk to develop such an injury as they grow older. Next, Your Honor, I want to just briefly touch on, I don't think it's terribly important, but Ms. Davis mentioned at the end of her argument that this other affidavit from a different case out of New York that Dr. Sands was an expert in. We don't know anything about that case other than what's in the affidavit itself, but what it doesn't state is Dr. Sands doesn't put in the affidavit, if I don't do a personal interview or evaluation of each plaintiff, then I won't offer the opinion. He doesn't say that. It doesn't speak to any standard as to assessments, and that's not a case where Dr. Sands or the expert on the other side was prognosticating an injury that is likely to develop. In that case, it was 2 plaintiffs who apparently had some current psychological issue, which they contended to be serious and were undergoing treatment for, and they claimed it was related to lead paint. And the defense argued that it was related to their father being very abusive to them. And that's what Dr. Sands is pointing out. That affidavit has, in my opinion, respectfully, little to no value at all. And whatever value it does hold, that's the exact type of evidence that you would see an attorney confront an expert with on the stand. In other words, it goes to weight, not admissibility. So, Your Honor, those are my points as to the admissibility of Dr. Sands' opinions overall. Before I transition to notice, do you have any questions on that area?
No.
Okay. So let's talk now about notice. And I brought more documents with me today to the extent they're necessary, but I don't think that they are. I think that the supplemental report is a perfectly adequate synopsis of what happened here, and it details from day one.
So your supplemental brief or what?
Yeah.
Okay.
And at the outset, the complaints in this case, which are part of the record, all of the parents assert individual claims. Throughout discovery, supplements were done. Well, let me just stick with the complaints. The causes of action were joined in, it was plaintiffs plural that are asserting the causes of action. The prayers for relief, plaintiffs, again, plural, and I'm happy to walk you through this if the court thinks it's a good use of time, but I don't want it to be overkill. The computation of damages counts for that. Dr. Sands reports, which I think is important. At page 4 of our supplemental brief, we cut and paste Dr. Sands's recommendations into the body of the brief. This is at page 4. For each child, it's the child and his parents. For Hera Carrier and her parents. Dr. Sands did that in each and every case. And he provides the amount of per session. And what we've provided for after he disclosed his report was it's basically the max total.
You plug the numbers in.
It's just addition of those numbers over from the child's current age till 18 or 21. And they had notice of that because the defense asked Dr. Sands in his deposition, are you talking about the parents? And we put a quote here at page 5 of our supplemental brief. I put the parents in here as well to see psychological and psychiatric evaluation and support because I'm confident that most of them unfortunately have post-traumatic stress symptoms and some may have post-traumatic stress disorder. I don't think that opinion is going to come as a surprise to anybody, considering what the parents have gone through in this case. But there's no question that defendants knew about it because they asked him about it at his deposition. Thereafter, the computations in every plaintiff's disclosures were supplemented to include that. Thereafter, in the brief, we put forth the numbers, and we also cite to the fact that in Gallagher, that claim went to the jury, and the jury awarded funds to the Gallagher parents. And so I don't think there's a question as to notice. And the only thing that changed here from Gallagher was that in this case, because we have a group of similarly situated baby plaintiffs, we opted to get an expert to help inform the jury's decision about what's likely to happen to these kids as they grow up. And the jury's going to be able to make an informed decision with the benefit of Dr. Sands' testimony as to what type of psychological care should we provide for these kids as they grow older? Because we have to do it now. We don't have the benefit of coming back 10 years from now and saying we need a little bit more money because one of these babies has developed a psychological issue. The jury has to prognosticate and take into account what the kids have gone through, and they'll decide. 103,000 is the max number based on the opinion. We couldn't ask for more than that, but the jury will be able to decide if that's too much. And they'll hear Dr. Sands' opinions on it. They'll hear the rebuttal experts, 2 of which were disclosed by the defense. And they'll hear the defendant's cross-examination of Dr. Sands, but to deprive the jury of the information it needs as to the children's pain and suffering here, I think would be very problematic, and it wouldn't lead to the best outcome in the case. Any questions, Your Honor, about notice or anything else?
I do not have any questions. Thank you. Any rebuttals?
Oh, Your Honor.
Yes, Your Honor.
Okay,
Please,
hold on.
Your Honor, hang on 1 second. One horse, one rider. They filed one joint opposition to this and one joint, and now Mr. Pepperman is going to argue again.
So we do have, let's see, at my request, I think 3 motions at least that we're arguing right now. Milwaukee, let's see, Milwaukee, MIL 4, Real Water, MIL 18, and Real Water's MSJ. Yeah,
I understand, Your Honor. I'm just, I don't think that they should be allowed to retread ground that was just tread by the carrier plaintiffs. That's all.
I'm guessing Mr. Pepperman's not gonna waste all our time, hopefully, so go ahead.
Thank you, Your Honor. I would just point out that Mr. Kaufmann and Mr. Freeman both argued there, and they represent the same client as opposed to me and Mr. Mirkovich, who represents separate plaintiffs in this action. But I do not intend to retread the ground that Mr. Mirkovich just did, which I think was very thorough and capable, and we join in those arguments. I just want to point out two additional things. Number one, on the fact sheet question where they say we did not disclose that we were seeking psychological damages, that is incorrect. First, this fact sheet was drafted by the defendants at the outset of this case. We actually had some disputes with it, but ultimately Special Master Hale allowed the questions as they were proposed by the defendants, which does not ask if any of the plaintiffs are seeking psychological damages. It asks only if you are seeking psychological damages, have you seen a psychologist previously? And the answers to those
He
questions
made that point.
were no.
So go to your next point.
So the next point would be the experts. And I know Mr. Mirkovich mentioned that the defendants do have their own neuropsychological experts too. Milwaukee and Realwater each have their own, Dr. Etkoff and Dr. Bailey. And this same issue came up at the time of expert disclosures. When we disclosed Dr. Sands, there wasn't an argument of, oh, we can't, Dr. Sands' opinions were untimely disclosed or some sort of ambush. The request was, can we have more time for our rebuttal experts? And would they be allowed to conduct interviews of the plaintiffs in the same vein that Dr. Sands did? And Special Master Hale addressed that. He allowed them the opportunity, if they so choose, to have their experts interview the plaintiff parents exactly as Dr. Sands did. He gave them their own extra time that they needed to provide their rebuttals on this, which they did. And their experts were disclosed on this same issue. They have their own. And these issues that are being raised, and I would respectfully submit, Your Honor, go to the weight given to this testimony, not to the admissibility, and certainly not to the viability of these claims as a matter of law, as Realwater is argued. Last point I want to make is with respect to Mr. Kaufmann's statement earlier that it's somehow telling or probative to something that we raised the pleading in our supplemental brief on this. Well, Your Honor, I would just remind the court that the argument on this at the hearing was they can bring these claims, but they never did because they didn't bring suit in their individual capacity. So the only point in the supplemental brief related to raising the pleadings is that was not accurate. The plaintiffs did allege that they are bringing these claims in their individual capacities, every one of them, and they're seeking these damages, which were the same damages that were sought in the Gallagher case and awarded. The only difference is the special damages related to psychological treatment, as Mr. Mirkovich, I think, capably argued before. So, Your Honor, we would agree that these motions should be denied and this matter should be left for the jury to decide.
Thank you, Wren. Who wants to go first in rebuttal?
I will, Your Honor. First, just a couple of points of clarification. Mr. Freeman and I argued separate motions. So there's that. Also, I would note a couple of things. My issue with them raising this and for their pleadings for the first time in supplemental reply is I raised them in my original motion and they were silent in their response. Technically, those arguments should have been waived. Also, I think that it's also telling that if you look at the dates for all the disclosures with these damages, they all come after expert discovery had closed, and Dr. Sands' deposition was not until, I believe, March 27th or 28th. I apologize, I don't know the exact date offhand. So that's well after, expert discovery is closed. And they keep referring to the Gallagher verdict, and I don't know how to make this any clearer. at the time of the Gallagher verdict, Real Water had settled with Gallagher plaintiffs, and we had no position on that line. In fact, this motion for summary judgment was filed because we thought that line was inappropriate in the Gallagher verdict. We just had no basis and no reason to object to it at the time. So the claim that it's some kind of waiver against Real Water, I just think is unavailing. And I believe the motion should be granted, Your Honor. Thank you.
Thank you very much. Anybody else in rebuttal?
Yes, Your Honor, this is Dawn Davis for Milwaukee. So I'll make this as brief as I can. Going back to this fact sheet argument, as I said, it's section 4 of the fact sheets that asks the plaintiffs to outline the type of claims that they're making, the type of injury claims that they're making. You can go through each one of them and not one mentions anything about making a psychological claim. I think Mr. Mirkovich sort of highlighted the issue here, which is the speculative nature of Dr. Sands' opinions. Like Mr. Mirkovich said, Dr. Sands has made no diagnosis. He cannot give the opinion that any of these kids presently have any cognitive issues, yet he wants to get up and tell the jury that each one of these kids should be evaluated for a decade plus. That is rank speculation. And I'll tell you what, back to a corollary of this notice issue, the affidavit that we submitted from Dr. Sands goes squarely to the issue that he testified about during his deposition, that regardless of whether he actually did a neuropsychological assessment of these kids, which he didn't, you cannot rest your opinion on exposure to a neurotoxin. He specifically says that exposure to a neurotoxin certainly is not the only risk factor for future neurocognitive issues. What the plaintiffs have done here in sort of springing this claim on us is prevent us the opportunity to do any of the discovery that we would have been able to do about any other type of a risk factor. Instead, what Dr. Sands proposes to do is just make rank speculation. Again, if Dr. Sands is allowed to testify, that testimony should be limited to, it's my opinion, that these kids should have a neuropsychological assessment. That still hasn't happened. He can't opine that any of these kids have any neurocognitive issues now, yet he wants to give the opinion that they might in the future. Your Honor, we cited the Zellers versus Next Tech case from the Fourth Circuit. That's a pretty similar type of a case. The plaintiff there was suing for injuries caused by excessive exposure to refrigerant gas. The plaintiff there offered a neuropsychologist to give similar opinions as Dr. Sands proposes, that this plaintiff had nervous system dysfunction as a result of neurotoxicity from the exposure. And there the court excluded that neuropsychologist's testimony because he wasn't qualified to diagnose any of these alleged symptoms. He didn't have his own opinion about any diagnoses. He had no other expert's opinion to rely upon. And the entire basis for the opinion was speculative. That's the exact same situation here, and I'll stop beating a dead horse, but again, Your Honor, the only opinion that could be appropriate from Dr. Sands is that these kids should go and have the neuropsychological assessment, so we know one way or the other if they have any deficits that would warrant any further treatment. And again, Your Honor, I'm happy to answer any questions, but it's just rank speculation to allow him to give these future opinions for treatment going off into the decades.
Thank you. Any other rebuttals?
Just
one point, and this is in regard to the parents' claim for damages. They quoted to Dr. Sand's deposition where they said, well, of course, there was notice of the parents because they said the minor plaintiff and parents. And Dr. Sands was confident that some parents suffered PTSD. The point is that he didn't do any neuropsych assessment of the parents. He didn't do any post-traumatic stress disorder tests or any emotional or neurological function assessment or testing. So there's no evaluation to support this confidence that some may have suffered. It's just clear speculation. Thank you.
Oh, thank you. Anybody else in rebuttal? Okay, thank you all very much. So we're going to do one order addressing the two motions in limine and the motion for summary judgment. Court's going to deny the motions in limine, deny the motion for summary judgment. On the motion for summary judgment, my initial inclination, deny because genuine issues of material fact exists and notice provided in discovery. So that's sticking with that. And additionally, some of these other things that I'm going to be going over in terms of reasoning for that. Certainly a lot of these apply more to the motions in limine, but they're all related in terms of notice, qualifications under Hallmark in terms of not necessarily Dr. Sand's qualifications, but him being able to offer opinions that qualify under Hallmark is how I put it. Hallmark and its progeny, because Hallmark's not the only case that goes through the standards. But I'm going to try to address, the main ones. But plaintiffs, you'll be preparing this essentially kind of global omnibus order, put these reasons in there, make it detailed. I'm not going to read your briefs out loud verbatim, especially like, the expert standards and those types of things, but circulate the order to everybody for review and approval. But to address some of the particular points, so, in terms of the summary judgment, part of that argument is there was no notice vis-a-vis the parents in the pleadings themselves. So that's kind of akin to a motion to dismiss kind of argument where you focused on the face of the pleadings. Nevada's a notice pleading state, and there's certainly notice in the pleadings that the parents are asserting claims, both on behalf of the minors and on behalf of themselves. And when I say parents, I include, to be clear, any guardian or guardians as well. So there's that. Cross these out as I go through them. The argument on, these aren't asserted in the fact sheets and therefore should be precluded. The fact sheets are not an end all be all to, whether it's to particular claims or particular damages arising from those claims, which is more apt here. The plaintiffs adequately point out, hey, these questions in the fact sheets are limited, and the way they're phrased and the answers do not rise to the level of excluding these types of opinions from Dr. Sands, and do not rise to the level of excluding these types of damages that plaintiffs are asserting based on Dr. Sands' opinions. Dr. Sands was timely disclosed as an expert. His reports timely disclosed. There was an opportunity, and defendants rightfully took advantage of the opportunity to depose Dr. Sands and follow up on his opinions. That, you know, goes back to this whole notice issue. There's clearly notice to, you know, such as to deny both the motion for summary judgment and the motions in limine to the extent they're based on a lack of notice. Dr. Sands is clearly qualified. I don't think that was really argued, but to the extent it was, he's clearly qualified to make these types of opinions. He, well, I'm kind of jumping all over, so hopefully in the order you'll be able to make it more coherent, but, you know, plaintiffs produced 16.1 supplements, included calculations, and those calculations essentially, you know, plugged in play the amounts set forth in Dr. Sands' reports to come up with those figures. So they're in calculations. There's some you know, whether to call it a disconnect, I'm not sure, but what Dr. Sands is saying isn't that necessarily that yes, plaintiffs, you know, the minors and the adults need this particular treatment or this, but as plaintiffs point out, it's going forward in the future, the evaluations to ensure that, hey, if it does rise to this level or that level, they'll be able to know and take care of that. And there's always, going in the future, there's always some level of speculation. But the level of speculation here vis-a-vis Dr. Sands' opinions does not rise to the level of exclusion. My next note, which dovetails right into that, most, if not all, of these issues go to weight, subject to impeachment and cross-examination. You know, the jury might side with defendants' arguments in terms of, well, this certainly appears to be rank speculation. But that's for them to consider. It is notable as well that defendants have their own experts to rebut Dr. Sands, at the very least, you know, to rebut Dr. Sands' opinions. And you know, that's part of plaintiff's argument, which I agree with. There's not this situation of some kind of ambush on the eve of trial, let alone any kind of ambush at the time of trial. So, you know, in preparing the order include standards, the rules, and cases in particular, some of those cases in plaintiff's supplement. Dr. Sands in his reports was up front, you know, it's so I'm just happening to look at the one I stickied. This is here a carrier applies to, so he lists out the documents reviewed, and this applies to every one of them. Hey, here's all the medical records that he reviewed, tests administered, test results, summary you know, are essentially based upon a review of the records and speaking with, in this case, Mr. and Mrs. Carrier, and the other cases, you know, the other folks he spoke with. So these don't rise again to the level of blanket excluding him or his opinions. Go to weight, subject to cross-examination and the like. Whether it was raised or not at Gallagher, and put this in the order because both sides kind of argued about it. It's really irrelevant to my decision. I'm dealing with, you know, what's in front of me, at least in this instance, and like I said, timely dispose, et cetera, here. So, and, you know, these are, you know, they dovetail in with, they're struggling to find a way out of it, but, you know, the consequences, alleged consequences, of ingesting the alleged contaminated real water. Raise obviously pain and suffering damages and these types of damages, although quantified similar to those using these types of treatment to treat that type of thing. So I mean, this is not a surprise, I guess, is how I would sum it up. But to make it very detailed order. So do we want to break for lunch or what?
What we have left, to be honest.
Maybe that's a good question.
While you were arguing that motion, I went back and looked at the reply on motion for summary judgment number 1, and I found the exact pages for you. It's page 6 and page 7.
Hold on, I got to add that to my note.
Yeah, and again, this goes to the issue of whether or not.
So the reply.
Yeah, the reply to MSJ number 1 on page 6, that has Dr. Tanner's testimony that real water was the cause for Christopher B. Wren, the father, and Christopher N. Wren, the baby. And then the following page, page 7, it has his testimony that's more likely than not real water was for Hera, the two Williams twins, and Morales. As I said before, he had no opinion. So I don't know how you argue that your expert could still give a medical causation opinion given that testimony, but that's where it is for your honor to review.
Anything on the defense? Like, do I have any other outstanding motions? Anybody?
We have 7 and 23, which was with regards to Dr. Tanner. But I think my position is those are moved, but Mr. Fears.
But apart from this issue, are there any like?
No.
Oh, okay.
We also have 25 and 26, they were deferred on 5, 7, 2.
Oh, yeah. 20. So these are plaintiffs MILs, 25. Don't get them out yet because they might tell me anything, don't need to do them, but plaintiffs MIL 25 to exclude Babcock. Did we do that one?
We're gonna defer that because I think that was a deferral. Yeah, that was deferral.
That's the deferral.
So that's.
There's a bunch that are deferred because we think they're gonna.
It's 26 the same, that's the exit one. Whole retained by.
Yeah, that's deferred.
Okay. The calendar call.
Yes.
Okay. So then the only outstanding issue, the Dr. Tanner / specific medical causation.
Yes, yeah, it's really how far does that new ruling on MSJ one go? And that will dictate whether we even address motion meeting number 7. 23, I think is moved because Henry would be the. There's actually multiple.
23 really went to the committee case.
Yeah, exactly.
Okay.
Went to the committee.
Okay. So then let me ask you all, do you wanna come back today? Or are you okay with me looking at things and coming back to talk about next time you're in front of me?
You can, I'm fine if you want to look at that. I think, I say, look at it if you want to come back, put a minute order. I just want to know how far that really goes.
Next time we come back.
It's May 20th.
May 23rd, what's,
Well,
oh, that's
yeah,
like.
calendar
two
calls, May 23rd.
Ish. You want to, you want to rule in on that well before that, right?
We can come back today or tomorrow and.
Let's
Just,
sanction.
I don't know when we set those for.
I thought we set those for next week.
I know they were going to be closed. I don't know the date.
Yeah, I thought they were pushed to next week.
so
What was it?
I don't know if we agreed on the date.
Sanctions motion with regards to real water and another sanctions motion. with regards to water. I was pushed sometime this week.
Yeah, that was the agreement. It was because both Mr. O'Do and Mr. Parker, they were originally on. He said at least one of them was set for today to accommodate the graduations. I don't know if we solidified a date.
that might have been what happened. Maybe.
The only thing next week is in chambers, OS. Business need to be justice. So that's in chambers. Everything else is set on May 23rd.
Okay.
We get sometime next week.
Yeah. Let's see. So I could have you either Tuesday or Thursday.
Either one you're on.
Thursday would probably be better.
And then I guess the follow-up question, so my 9 o'clocks looks a little heavy on both days. We're not trial, right? I think I was gonna have. Can you ask Amanda if she set me for a criminal settlement conference? And if so, what date? So rather than put you on a 9, it's probably more sense to do you like at an 11 o'clock if we have it. Okay, so you wouldn't be on Wednesday anyway. So yeah, I could do 1 o'clock on either. Well, let's say 1:30, either Tuesday or Thursday. Thursday. Okay, so 1:30 Thursday. Tenor specific medical causation, and then there's 2 pending spoliation motions.
That's correct.
Is that right? Okay. See you in a week.
Thank you, Your Honor.
Thank you.